A crack has just appeared in the foundation of one of America's most notorious convictions, that of the Menendez brothers. And I'll be honest, I almost missed this news entirely because early this morning, I woke up like a little bit too early and I told myself, don't look at your phone, don't look at your phone. I could go back to sleep. And of course, I ended up like scrolling with one eye open through Facebook. And that's when I stumbled across a post from Lyle Menendez's Facebook page, which his wife runs. And they shared a new article that was posted just hours earlier with the headline, Menendez conviction called into question. And let me tell you that snapped me wide awake. I jumped out of bed and I began immediately digging. And I found a few articles confirming this. And then I headed over to YouTube and I caught Mark Geragos, attorney for the brothers, talking about this huge news on the Reasonable Doubt channel. You should go check them out if you haven't already. It's a wonderful way to get information directly from Geragos. In just a few minutes, he laid out exactly what was in that news article. And it's true. With a single court order, the state of California, which won such a decisive conviction in 1996, is now suddenly on the defensive. For the first time in over 3 decades, the Menendez brothers have a legal victory that doesn't just question their sentence. It questions the very trial that put them away for life. Just last week, during the week of July 6, 2025, Los Angeles Superior Court Judge William C. Ryan did what decades of appeals couldn't. He ruled in favor of the writ of habeas corpus. Now, habeas corpus is a Latin term meaning you shall have the body. It's one of the oldest and most powerful tools in our legal system. It's a fundamental right that allows a prisoner to challenge the legality of their detention before a federal judge. It's not an appeal. It's a direct challenge to the state, asking a simple question: is this imprisonment constitutional? For decades, the answer for the Menendez brothers was yes. But Judge Ryan has now said, well, maybe not. His ruling triggered what is known as an order to show cause. This is a profound legal reversal. For 30 years, the burden was on the Menendez brothers to prove they deserved a second chance. Now that burden has shifted. The court has ordered the Los Angeles District Attorney's Office, led by Nathan Hochman, to come to court and justify, to show cause, why the brothers' convictions should not be thrown out in light of new evidence. The reason for this stunning turn of events is Judge Ryan's explosive finding. After reviewing the new evidence, he concluded that the new evidence would have more likely than not changed the outcome of their second trial. Let's let that sink in. A judge has officially stated that the jury that sentenced Lyle and Erik to life in prison was deprived of information so critical it likely would have altered their verdict. The conviction, once seen as ironclad, now appears completely, deeply flawed. Now, as most of us know, in August of 1989, Lyle and Erik Menendez shot and killed their parents, Jose and Kitty, in the family's Beverly Hills mansion. The murders were brutal. Jose was shot point blank in the back of the head, and Kitty was shot multiple times as she tried to escape. The first trial, which began in 1993, was nothing short of a national phenomenon. A fledgling network called Court TV broadcast the proceedings live, and America was absolutely captivated. With 2 separate juries, one for each brother, defense attorney Leslie Abramson argued that this was not a murder for money, but a desperate act of self-preservation. She introduced a concept that would polarize the nation, called imperfect self-defense. The brothers, she claimed, killed their parents not because they were in immediate danger at that very moment, but because a lifetime of horrific abuse had led them to genuinely, if unreasonably, believe their parents were about to kill them to keep a dark family secret buried. And that secret was explosive. For the first time, the brothers testified to years of relentless abuse some of it sexual, by their father Jose, and crippling emotional abuse from their mother Kitty, who they claimed enabled their father's abuse as well. The testimony was graphic, disturbing, and for many, just a little bit unbelievable. The result was 2 deadlocked juries, and then later, a stunning mistrial. The prosecution's seemingly airtight case had been stopped in its tracks. It turned out that when the jury heard the full story of the alleged abuse, at least some of them couldn't bring themselves to call it cold-blooded, premeditated murder. So the nation was divided, and the stage was set for a retrial. In the second trial, beginning in 1995, it would be fundamentally different. The district attorney's office, stung by this mistrial, it wasn't going to make the same mistake twice. And presiding Judge Weisberg made a series of rulings that would completely reshape the legal battlefield in this case. First, he completely banned television cameras from the courtroom, plunging the proceedings into relative darkness after the spectacle of the first trial. He then consolidated the case before one single joint jury, but his most fateful decision was aimed directly at the heart of the defense. Judge Weisberg severely limited the defense's ability to present evidence of the abuse. He ruled that there was insufficient evidence to support the claims, and critically, he barred the jury from even considering the imperfect self-defense theory. This was a legal death blow. By removing the option of a lesser charge like manslaughter, which acknowledges an unlawful killing but with mitigating circumstances, the judge left the jury with an impossible choice: first-degree murder or a full acquittal. Since the brothers had already admitted to pulling the triggers, acquittal was never really a possibility. The outcome was a direct consequence of these judicial maneuvers. The second trial wasn't a replay. It was a different game with different rules, all designed to lead to one conclusion. In March of 1996, the jury delivered the verdict the prosecution had sought all along: guilty of first-degree murder. Lyle and Erik Menendez were sentenced to 2 consecutive terms of life in prison without the possibility of parole. And for decades, that was just the end of the story. But then something shifted. In the 2020s, a new generation, armed with social media and a different understanding of trauma, began to re-examine the case. On platforms like TikTok, millions of young people watched old trial footage and came to a completely different conclusion. They saw not greedy killers, but traumatized victims. This grassroots movement was amplified by a new wave of true crime media, most notably the 2024 Netflix series called Monsters, the Lyle and Erik Menendez story, which brought the case roaring back to the public consciousness. This renewed interest coincided with the Los Angeles District Attorney's Office announcing it was reviewing new evidence in the case. This cultural reappraisal reflected a profound societal evolution. In the 1990s, the brothers' claims of male sexual abuse were often met with ridicule and disbelief. As their own aunt, Joan Anderson Vandermolen, later stated, the world in the 90s was not ready to hear that boys could be raped. Today, society has a much more nuanced understanding of trauma and victimhood, creating a new lens through which to view the case. This swelling of support found an official ally in then Los Angeles District Attorney George Gascon. In October of 2024, Gascon announced that he was recommending the brothers be resentenced, stating that his belief that they had paid their debt to society. For supporters and family, it was a seismic shift, the first time in decades that the prosecutor's office was on their side. But that hope was very short-lived, because in the November 2024 election, Gascon was defeated by Nathan Hochman, and Hochman quickly and completely reversed course, announcing that his office would oppose resentencing and any new trial. He argued that the brothers had not taken complete responsibility for their crimes, continuing to lie about their self-defense claims. The move sparked outrage among the brothers' family and supporters. The family-led Justice for Erik and Lyle coalition accused Hochman of bias and even demanded his office be removed from the case after a contentious court hearing where prosecutors actually displayed graphic crime scene photos, an act the family called cruel and careless, which led to the hospitalization of the brothers' aunt, who for the past 30 years had never seen those gruesome photos of her murdered sibling. It was in this new climate that the two pieces of evidence at the heart of the recent court hearing emerged. Both of these new pieces of evidence were submitted in 2023 with the Habeas petition. Evidence that they said directly attacked the prosecution's core argument that the abuse was a lie, that their story was fabricated just for trial. The first piece of evidence was a letter allegedly written by Erik Menendez to his cousin Andy in 1989, just months before the murders took place. In it, Erik complained about his father's ongoing sexual abuse. This letter, only recently discovered after Andy's passing, provides contemporaneous corroboration. It shows that the abuse was a reality for Erik long before any lawyers were ever involved, directly refuting the recent fabrication theory that won the second trial. The second piece of evidence was a sworn declaration from Roy Rosello, a former member of the popular 80s boy band Menudo. Rosello claims that Jose Menendez, who was an executive at Menudo's record label, RCA, drugged and essayed him when he was just a teenager. This provides powerful third-party corroboration. It paints a picture of Jose Menendez as a predator from a source completely independent of the family, making the brothers' long-held claims about their father's character infinitely more credible. So together, these two pieces of evidence provide exactly what was missing in 1996. External validation, which is what this Judge William Ryan just agreed with, since he found that these pieces of evidence would have likely changed the outcome of that second trial. In other words, he's saying this new evidence doesn't just add details, they fundamentally alter the credibility of the entire defense. This brings us to the complex legal landscape of today, where the Menendez brothers have scored two separate monumental victories this year of 2025, creating two distinct paths to potential freedom. Some of you already know the first came in May, based on changes in California law regarding youthful offenders and a finding that the brothers are no longer a threat to society. Judge Michael Jesek reduced their sentences from life without parole to 50 years to life. Having already served 35 years, this ruling made them immediately eligible for parole. Their first hearing before the parole board is scheduled for August 21st and 22nd. The second victory, again, is this new July habeas corpus ruling. This path is entirely different. It's not about their sentence, it's about their conviction overall. It asks whether their trial was constitutionally fair to begin with. If this district attorney fails to show cause and their writ is granted, their 1996 murder convictions would be vacated entirely. So this could lead to a new trial, a plea deal, or a lesser charge like manslaughter, or even their immediate release. These two paths run in parallel. They could be granted parole while the habeas is still being decided, or the habeas ruling could invalidate their convictions, making the entire parole process moot. Now, I have covered many cases over the years, but the Menendez story has always stood apart from me. But I'll be clear, what Lyle and Erik Menendez did on August 20th, 1989 was a horrific act of violence. They brutally murdered their parents. Nothing can or should ever excuse that. But the debate has never been about whether they killed them. It is about why and whether the punishment fit the crime. And watching the recent developments unfold, for me, it isn't impossible not to see the 1996 conviction as a product of its time. It was a time that was deeply uncomfortable with the idea of male sexual abuse, a time when such claims were easily dismissed as the abuse excuse. Judge Weisberg's rulings in the second trial, while perhaps legally sound under the rules of the day, created a process that for me feels, in hindsight, just completely fundamentally unjust. My biggest problem with this whole case is that second trial denied the jury the full context, the full story, that the first jury had been allowed to grapple with and were unable to reach a verdict. So to me, the judge literally took away their ability to consider a middle ground, to see the gray in a case that was anything but black and white. The recent court rulings aren't about exonerating the brothers or declaring them innocent. They are about acknowledging that the system in 1996 failed. It failed to give proper weight to evidence of profound long-term trauma. It failed to provide a trial where the punishment could be truly debated. Justice shouldn't be a static event, frozen in time. It has to be an evolving process, one that's willing to look back and correct its own mistakes when new evidence or even just a new, more enlightened understanding of human psychology reveals a past error. The question before the courts today is the same one that should have been properly asked in 1996. Not if they killed their parents, but what crime precisely did they commit? Murder? Or was it manslaughter, born from a lifetime of terror? That is the question the second jury was never allowed to answer. And it's the question that the justice system may finally have to confront. So to recap, two critical events now lie on the horizon. In August of 2025, the California Board of Parole Hearings will convene to decide if after 35 years, the brothers are suitable for release. And that hearing again is set for August 21st and 22nd. Now, at the same time, the Los Angeles District Attorney's Office now has 30 days, less than 30 days from today, to prepare its response to the court to show cause, why a conviction built on a narrative of lies should stand, now that the new evidence suggests that the lies may have been told by the prosecution itself. For 3 decades, the story of Lyle and Erik Menendez had a clear, unambiguous ending written by the state. But now, the final chapter has been torn out and the pages are blank. Now, what do you all think? Will this story end with freedom granted by a parole board? Or a new trial ordered by the judge? Or a return to the status quo with the system defending its past decisions to the bitter end? Can a legal system, after so long, truly deliver a verdict that reconciles the horror of the crime with the horror of the abuse that may have fueled it? So let me know what you all think in the comments section down below, but that's going to be it for me today. For those new to my channel, my name is Tara Marie, and this has been an episode of True Crime Matters with Tara Marie, where we talk about and analyze everything true crime. If you have gotten any use out of today's video, please take a second to subscribe so we don't lose each other. It costs nothing, and it would mean so much to me to have your support along the way. And as always, thank you so much for watching. Be careful out there.